Bonani Ninjani, Molweni Afsheni, guys. Today we are here with the customary law. Most of you who are doing customary law, you have this question, and I believe that you are now starting with your assignment. And here is your best tutor. I'll try to help you with all I can, so that you know where to start, where to look for things, and where to get things done. So let's start with the business of the day. Question number 1, which we're going to deal with it on this video. Then question 2 will deal with it on the next video. So make sure you watch all the videos in order to understand. Question number 1, discuss the implications of section 211 subsection 3 of the Constitution Act 108 of 1996 for the recognizing of customary law. Let me repeat this question. Discuss the implications of section 211 subsection 3 of the Constitution Act for the recognizing of customary law. Here we have the Constitution of the Republic of South Africa, number 108 of 1996, and let's go straight to the section which provided on the 2111 chapter 12 deals with the traditional leaders, and 211 deal with the recognition. It stated very clear that it's 2111 subsection 3, which will look on to subsection 3. It says the court must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. Let me repeat this. It says the court must apply customary law when that law is applicable, subject to the Constitution and any legislation that specifically deals with customary law. So it means that here, this chapter 12 is granting the court to apply customary law when the law is applicable. Now we have understood the 2111 subsection 3. You must understand that before you go forward dealing with that question, that we understood that the court is mandated to apply customary law. However, it is very much important to come to the Bill of Rights and check section 39. Remember, section 39 of the Bill of Rights, it has a subsection 2, which stated very clear that when interpreting any legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and object of the Bill of Rights. Let me repeat this one, because this one is very much important, like that one of 2111. It says when interpreting any legislation, when developing the customary law, every court, tribunal, or forum must promote the spirit, purpose, and object of the Bill of Rights. So as a result of that, we are going to look on the cases of the customary law which were applied, and then they promoted the spirit of purpose and object of the Bill of Rights. So this is one of the other summary that I've made for you to understand. Section 39, subsection 2, the one that we're reading, it stated that when interpreting the legislation, then the customary law, it should be the court or forum must promote the spirit, purport, object of the Bill of Rights. Then I said on the downwards that the Constitution made it clear that the Bill of Rights is the cornerstone of our democracy. In the battle Starfishing, the LTD versus Minister of Environmental Affairs and Tourism, the court held that the Constitution is the initial point to interpret any legislation text. The interpretation on the statute should advance one value underlie on the Bill of Rights. The words in the statute must be clear and unambiguous. Langer emphasized that Section 39, subsection 2 of the Constitution ensure that all legislations are interpreted through the prism of the Bill of Rights. The process of interpreting the Constitution should invoke the context which achieve the constitutional goal of a society based on democratic value, social justice, and fundamental human rights. So now I've made it clear for you in order to understand section 39.2, so subsection. Then we are here. Here is where we look at on the cases which were decided. The customary cases. Number one is that section 7, subsection 2 of the recognition of customary marriage. If you do not know this act, go and look for this act. Introduce a new requirement for valid marriage of a second wife by requiring the husband to seek his first wife's consent. Remember, in the previous, a man who needs a second wife just go on the street and come back with a second wife. However, this was seen as a disrespect for the first wife, because first wife is just a person who is not being recognized for their value that she's playing. Therefore, this thing has to be changed in a way that the first wife has to give a consent for the second wife. And this was decided in the case of Ngwenyama Miane, which is the case that you have to let me put it like this: Ngwenyama versus Mayelane 2012, which you have to go and look for it. The applicant challenges his husband on the grounds that he married second wife without her consent. The Supreme Court of Appeal held that the above section deals with the matrimonial property and not the validity of marriage. The Supreme held that the marriage was valid. However, the issue of consent was not resolved, as the court held the view that marriage was valid. In the Constitutional Court, the court decided to develop stronger customary law to include the rule that the first wife consent to her husband's further marriage to another woman is a requirement for a valid of a further marriage. Although consent was not stipulated on the RCM, which is the recognition of the Customary Marriage Act, the court developed it as a common law. So now we know that there's a new common law according to the stronger customary law that was developed by the court, which is the first case, that if you want a second wife, you have to ask permission or consent from the first wife, and the first wife has a right to say no. The court held that the consent brings respect, and therefore it is valid to all tribals. So as a result of that, nowadays the consent is a requirement. So the marriage, in order to be valid, you have to go to the first wife and ask permission to get the second wife. The court held that the person who married a second wife without first wife consent will amount to invalid of marriage. It means that if the first wife was not consulted when you married the second wife, the marriage now is invalid, which has brought a respect for women. And I believe that is the thing that many women do not know out there. Let's go forward. Sorry. The marriage was declared invalid as husband never obtained consent from wife. The minority judgment argued that the fact that there was lack of consent from first wife means such marriage was never negotiated and entered. It means that this marriage was declared invalid or in the Constitutional Court because there was no consent from the first wife. It means that there was no negotiation. It was just about another party exercising the power or the supreme power over another party because he is disadvantaged. So the man just has to prove that it's a man by just taking any wife anytime. But now you know the case. This case is very much important for you You have to put it down like this so that you summarize this case. It's a development of a customary law. You must not forget that there is something called the official and living customary law. And this was confirmed by the case of Bear versus Khayelitsha Magistrate, where the court distinguished between official and customary law. Official customary law and living customary law. The official law is applicable in court and is found on statutes, law reports, textbook, and public documents. So this one, official law, is the one that is applicable in court. Living customary law involves in practice that indicates the community has chosen to live and regulate the various kinds of relationships between members of community. Living customary law. Now we'll be discussing the living customary law because this one is very important because many courts are not applying the living customary law. I told you that living customary law is a practice from generation to generation. Living customary law depends on morality. The court depends on positive law. The two interpretations make it difficult for living customary law to be applicable in court. These are the challenges with customary law because customary law depends on the living customary law. Living customary law changes rapidly in response to the current lifestyle. And then there was the case of Shiluvana where the court changed the rule of primogeniture in favor of Shiluvana to be the queen of Baloi. Baloi. This is another case which is very important for living customary law. However, it was the case that Shiluvana, who is the queen, who is a woman, was discriminated and they favor a male as the king of Baloi. Then they went to court and they written their law in line with Section 9 of the Constitution. This was in line with Section 9 of the Constitution, which advocated equality based on gender. It is clear that there is a greater difference between the official customary law, which is primarily based on the written official documents, while the living customary law is founded on the generation to generation practice, and which involves according to time and as their lifestyle evolves and changes. So these are some cases to add on that. In the Bear versus Magistrate, Khayelitsha, and others, the court dealt with the rule of male primogeniture. The Constitutional Court declared invalid the principle of male primogeniture on the grounds that it discriminates against gender equality. Remember, primogeniture is that one that the firstborn of a male is the one who must inherit. This was dealt with and is invalid. So if you still have this practice, you must change it. The court abolished it for the purpose of succession. This resulted in the imported of interstate succession into customary law for the benefit of all who are eligible for succession. So this case played a very, very, very big role for succession because for succession in the olden days, only the firstborn with a male must inherit. But now, for succession, everyone is eligible for inheritance. This was provided by the reform of customary law, which is that legislation which you have to look for. The case ended with Section 23 of the Black Administration Act, which prefer men over women in the law of succession. Remember, a Black Administration Act was passed early before this one, and it advocated the male primogeniture. Then this Section 23 advocated the male primogeniture. However, it was repealed because this law, the primogeniture, was declared invalid. And we look at another case of the Shiluvana and others, versus Nwamitwa, 2008, where the court focused on Section 21112 of the Constitution, which empowers community to make and amend their laws. The Baloi amended their own customary law. The primogeniture rule was declared unconstitutional even in the sphere of traditional leadership. The appointment of Pilea Shiluvana as a traditional leader was confirmed. Most importantly, the power of the Baloi traditional authority to amend their customary law was affirmed. In this case, customary law was aligned with the Constitution. Remember, in the case of Shilubana, Shilubana was a woman who wants to be a king. And then, in order for her to be a king, they decided to make and amend their laws. They develop and amend their laws that this is the practice, this is the new practice for us. Like in KwaZulu-Natal, they have amended and developed their laws. There is a Natal customary law. If you can read on the book, you'll find that on how it's done in case ZN. However, there was a challenge in which the court are unable to deal with it in the case, and these developments are either compatible or incompatible with the idea of decolonizing the South African legal system. Because of one way or another, the original customary laws are eroded. The man is regarded as the head of family, although these cases are trying to bring the gender equalities and equality, your equities and equality. Women are a targeted group in South Africa. The fight and conflict arise because of a throne is unbearable. Shilubana became a queen, but some rights were violated, like she must choose a man from Baloyi family. The benefit of children and wife-in-law of succession is compatible with the colonization. Some of the challenges. Let's look on the other case of the case of the recent, and we will look also on the case of Mpepu Ramabrana and others. The court held that to recognize Tony Mpepu promotes gender discrimination and are reviewed and set aside in that the discrimination impairs compliance with the provision of 2A4C of the Traditional Leadership and Government Framework Amendment. And in the case of Mtembu, that's where they said the primogeniture has to be reformed. So let me talk about the case of Tony Mpepu so that you understand what happened to the case of Tony Mpepu. If you can look here, this is Tony Mpepu, the king of Venda. This one. This King Tony Mpepu is the king of the Venda. He's the king of the Venda tribe. You can see him here with a Cyril Ramaphosa. Yeah. So this one over here is a Tony's sister. So what happened is that Tony's brother, the elder brother, remember that time the Venda people used the male primogeniture. So the elder of Tony, or the brother of Tony, the elder one, was the king of Venda in the early 90s to 1997. Then he got an accident and died. Then he had a child, and that child is this woman. She was young when the daddy died of accident. Then as a result of that, Tony Mpepu, as a younger brother, was the successor, as they don't recognize a woman as a queen in Venda. Then Tony became successful as the king of the Venda. Then this woman was young. She was young. I think she was born in 1994 or 1995. Then when she started to grow up, she started to fight for what is rightful for her, saying that I'm the rightful heir and I'm discriminated because I'm a woman. Which I think, for me, if this woman was a man, she would be the rightful heir. But because she's a woman, she's not a rightful heir. However, the Venda people also concerned about the the kingship of the Venda tribe, which they cannot give the other. Remember, within the Venda tribes, there are many tribes. So they cannot sell their kingship to another because this woman may be married by another royal family. And for them, it's like selling the kingship. So they weren't allowed to give a woman the kingship. Now it has been reserved, saying that this Tony Mpepu is not the rightful owner, the rightful person for the king, and that he was the king because out of the discrimination. Remember, when this lady calls Tony, she calls Tony an uncle. However, some suggested that this Tony and this woman must meet and sleep with each other to have a baby, which the baby will be the king of the Venda tribe. So we don't know now what's going on. Now the case is still ongoing. The matter is still ongoing in the royal family. It's up to them to discuss and decide. And last thing, guys, do not rely on the chat GPT when you want information, and do not rely to this thing. Rather, watch our YouTube channel so that you gain more knowledge, because this thing won't lead you anywhere. You can come here and say cases of this thing is not guaranteed, and it won't give you an answer because there is no answer. That's why I'm saying that even if you can go to this chat GPT or the Perplexity AI, it's not easier for you to find cases. Even though you can find cases, you still have to ensure that those cases are correct. So it's better you watch our YouTube channel and you learn about the cases that are based on the real research, rather than this thing of chat GPT or this thing of Perplexity. So watch our channel to get more information rather than relying on those sources that will make you a failure. We are all building each other in the law, and I will be happy if you can comment and give more comments. I've given you more cases to deal with it. I've given you enough information. Now you know where to start, and you have to read, of course, the book. Then you know. We'll meet when we deal with question 2. We will meet when we deal with question 2, which I will upload the video about the question 2, which will be asking about the proprietary consequences of the customary marriage. I hope now you know where to start with the implications of section 21113 of the Constitutional Act. I've given you some cases, and you have a lot of information which you must read. And then for the purpose of reading, I think that it will be very much important for you to grasp this transformative constitutionalism and customary law by Annika Gleisen and Geoff Bladen. I've wrote this journal. This journal is very good. If you can read this journal, you'll be able to answer that question very, very, very fast. I have read this journal, and I found this journal very, very, very understandable. And for me, I believe that if you can go and read it, you will gain a lot of information. All the cases are here, and they even told you about things. I remember, I love to read here where they say, before one looks at the 2013 judgment, one has to talk on how far this project and progressive in the Constitutional Court by their time. Certification judgment, leave it aside. Then there's this certification which you have to read. I forgot to mention this case. I always forgot to mention this case, but I hope that you will mention this case when you are doing your when you are writing it down. The question number 1. This guy said that the court laid down 5 far-reaching principles, and these principles are very much important. Firstly, the customary law is subject to the Constitution. We're talking about this one. Number 2, second, the customary law must not be viewed through a common law lens. And then the third, customary law involves and developed to meet the changing needs of the community. And fourth, while customary law can be established by reference to writers on the subject, caution is to be exercised when dealing with the textbook and old authorities. So I think that this guy, there's more information that you can learn and able to pick up and write. So remember, go and read these journals. And if you need more journals, I can provide you with more journals. Okay, thanks very much, guys. It was for today, and I will upload another video for part 2.